A very good afternoon, East Africa, ladies and gentlemen, wherever you are joining us from. Would like to welcome you to this very special webinar session that is discussing data, privacy, and AI. And this afternoon, we are joined by a very distinguished panel of experts that have distinguished themselves in this field, and we are happy that gradually we are moving towards the right direction in promoting AI and data protection. This afternoon's session is proudly hosted by our Data Protection Committee of the East Africa Law Society. And we are very glad that this afternoon we have showed up here in very large numbers to join this very pertinent discussion that is going to shape our understanding of data protection and privacy. And today's topic will be looking at privacy laws as a pillar of AI governance, and we'll be looking at emerging roles for legal practitioners. And to take us through this afternoon is a very distinguished panel that is moderated by our very able moderator, who is a Rwandan attorney whose research and interests focus on how intellectual property law, data protection and privacy laws, AI, and intersectional theory can be creatively used to advance social justice in emerging technologies. She's a fellow in Georgetown's Leadership and Advocacy for Women in Africa and Women's Law and Public Policy Fellowship. She's a contributor to Tech Policy Press and serves on the East Africa Law Society's Research and Publications Committee and the Data Protection and Privacy Committee. She holds a Master of Laws in Technology Law and Policy from Georgetown University Law Center, a Bachelor of Laws from the University of Dar es Salaam, and a Diploma in Legal Practice from Rwanda's Institute of Legal Practice and Development. She's currently an affiliate fellow at the Georgetown Law Center on National Security and an investigator on Levy Firestone Muse LLP. Ladies and gentlemen, put your hands together and welcome with me Ms. Fabiola Uwera, who is our moderator this afternoon, and she'll have us from now till 4 p.m. Our session shall be streamed on Zoom and YouTube, so please share the link so that a friend can join. Otherwise, we urge you to enjoy the session. Over to you, Fabiola. We are eager and enthusiastic to learn. Thank you.
Thank you so much for the warm introduction. I love your energy. It's early in the morning here, and I needed that. Good morning, everyone. My name is Fabiola, as introduced, and I'm very pleased to be here. Thank you to Gabriel Achaye and the whole team at the East Africa Law Society for coordinating this webinar. I'm honored to be joined by legal experts who are not just observers of the rise of AI, but they have been actively preparing for it, setting legal foundations and ensuring people's rights are respected along the way. I know some of us might have concerns about being replaced by these new AI tools someday, or mass surveillance, or AI biases, or misuse of personal data. So today we are pleased to have legal experts to take us through and unpack all these issues and shed light on how privacy and artificial intelligence intersect within the East African legal framework. And I'm also eager to hear from them how more legal practitioners can step in this emerging field. And welcome you all. I think to make justice to your expertise, I will welcome you to introduce yourself. Thank you so much again for making time for this panel and agreeing to share your insights on this topic. I would like to welcome each one of you. Please say hello to our audience and briefly tell us about yourself and your work. And if you don't mind, I'm excited for this. If you don't mind, please translate artificial intelligence in your mother tongue. Let me start. In Kinyarwanda, artificial intelligence has been translated as ubwenge mpimbano or ubwenge bukorano or ubwenge buhangano, but we haven't agreed on the right translation. So yeah, please tell us briefly about you and your work and what is artificial intelligence in your mother tongue. Thank you.
Thank you, Fabiola. I think I can go ahead. So my name is Miss Wendy Kuyo. I'm an advocate of the High Court of Kenya. I'm pleased to be here. I work as an associate in a firm called ICT Legal Consulting International. So we are very highly specialized. We practice data protection law, also leveraging on the frameworks, the EU General Data Protection Regulation, as well as other country-specific legislation, and not just within the EU jurisdiction, as well as from Africa. Also in relation to AI ethics, as well in line with the newly published AI Act, as well as best practices in relation to the African context that has not yet enacted legislation. As well, new technology laws like the Data Act, Digital Services Act, etc. And in my mother tongue, I would not say mother tongue per se, but something that is a language that is common also across the East African region. In Swahili, we have translated artificial intelligence to be akili mnemba, or some other people would also say akili unde. So that is artificial intelligence, and I'm happy to be here, and I look forward to the conversations by the panelists. Thank you so much.
Thank you so much. Next, Dorothy, could you please?
Good morning, good afternoon, and good morning, everyone, depending on where you are. My name is Doreen Wanjero. I am an Principal Data Protection Officer at the Office of the Data Protection Commissioner in Kenya. I am also an AI Policy Fellow from CIPIT in the Strathmore University. I am an AI Policy and Ethics champion. I am excited to have this conversation with you today. Thank you. And also in translation, I associate with Wendy's translation since we come from the same jurisdiction.
Thank you. Mr. Otieno, could you please go next?
Thank you, Fabiola. Can you confirm you can hear me?
Yes, we can hear you.
So hello, everyone. My name is Quincy Otieno. I am legal counsel at the Kenyan Parliament. I am an AIGP, CIPM, AI governance, particularly focusing on creating frameworks currently. Then I do teach and train on AI safety and alignment at Paradigm Synergy Enterprises. Equally, I am a member of the Data Governance and Professional Society of Kenya. Translated, let me take a more community-based approach to defining AI. So in my local mother tongue, we call it Riekmar computer, just meaning and translated artificial intelligence. In very many boardrooms, I think the Wendy's definition actually suffices, and I'm happy to be here.
Thank you.
I think it's my turn. Yeah. All right. So my name's Dorothy Ndazi. I'm a partner at Hilton Law Group. I am a specialist in telecommunications, media, and technology law, and specifically in the data protection law, where we partner with the Personal Data Protection Commission here in Tanzania to advance this data protection law, which is actually quite new in this jurisdiction. So, and again, like my colleagues from Kenya, we use Akili Mnemba for artificial intelligence. Nice to be here. I hope to have a very meaningful session. Thank you.
Thank you so much especially for the translation. I know in Tanzania, in Kenya, I think in all the countries there has been debates about the right translation. In Tanzania, some people used to say it's akili bandia, which would mean akili fake. But I think the right translation should be, I mean, it's not my place to give it, but I think Akili Mnemba is the right translation. Thank you so much. For the audience following us online, please drop your translation in the chat, and we will see. Please, if you have dialects, your mother tongue dialects, please try to think about it and drop the right translation in the chat. Thank you. So without further ado, I would like to welcome our first speaker, Wendy, who is an associate at the ICT Legal Consulting. We would like you to discuss how to navigate privacy laws for AI compliance. Please, can you please tell us how do East Africa's current privacy laws align with the growing use of AI systems, particularly when it comes to areas like data minimization, informed consent, automated decision-making, and data protection impact assessments? And also, could you please share what has been the biggest compliance challenges you've observed in your practice?
Thank you. Thank you, Fabiola, once again. Good morning, good afternoon again, from wherever you're joining us. So I would start by giving all of us a brain teaser. So whether you're an external legal counsel or in-house counsel, and imagine your client or your organization is a fintech AI platform. So maybe the platform has been developed in Nairobi, either in Kigali, in Bujumbura, etc. And it offers instant loan approvals. So based on a customer's or a consumer's smartphone metadata. So what I mean when I say metadata, I mean data providing information about one or more aspects of an individual. So smartphone metadata maybe can be derived from SMS messages, call logs, or even location data. So the idea maybe by the developers within this company or your client's company is that it promises speed, efficiency, and inclusion. But again, remember, it is an AI platform. So this automatically, as a legal counsel, whether internal, external, your advisory point of view, or even data protection officer, which is DPO, it brings about, it raises critical questions. It raises privacy concerns. For instance, if the individual has been denied a loan, is this fair? Is the decision fair? Who can challenge it? It also raises questions in relation to the ethical use of AI, which I am sure my other esteemed panelists are going to expound a bit more. There are questions on bias, which would be expanded by my colleagues. So here we see a balance between privacy concerns and the right, and also the right to maybe access to credit, financial inclusion. So we see a good thing here, but then we see a balance. So firstly, I would like to also recognize the various privacy framework within the East African region, which, for instance, we know the foundation are in most of the constitutions. For instance, under Article 31 of the Constitution of Kenya, for Ugandan Constitution under Article 27. So privacy is enshrined there. And then there are other laws that are transpolated from this right to privacy, for instance, which I would call maybe, I would call enabling frameworks. So for instance, the Kenyan Data Protection Act of 2019 and its subsidiary regulations, of course, to be interpreted with other guidance notes as has been issued over time by the Office of the Data Protection Commissioner. The PDPA, Personal Data Protection Act of 2022 in Tanzania, the Data Protection and Privacy Act in Uganda, etc. So bear in mind, because the audience is quite diverse, I would make reference to principles or rather provisions within the legislation that cut across these pieces of legislation, just to tie in how this legislation shapes or rather intersects with artificial intelligence. So you may ask yourself, so there is privacy legislation, there's data protection, and there's privacy, there's data protection, and there's AI. What is this correlation? So the correlation might be much more complex, but you may wonder, what has privacy have to do with AI? So in summary, AI systems, as we may already know, are trained on data. And some of this may be personal data, including names, including surnames, including emails. So this data actually serves as the foundation for teaching AI models in order to recognize patterns, in order to make decisions, and in order to improve their performance over time. So in my presentation, I would in brief highlight some of the peculiar principles that cut across the region, and that would be useful in order to look into how this sort of case study that I have provided to us would apply as concerns these privacy laws. So imagine that this app, this AI platform, collects maybe GPS location, contacts list, and even social media activity, even though they are not strictly required. We see that these pieces of legislation outlines various principles. For instance, data minimization principle, which I would highlight as a first, and then tie in with other relevant principles. So in general, these data minimization principles would highlight that a data controller, or rather, let's say the company developing this AI platform should limit the amount of personal data collected to what is necessary for the purpose. So there needs to be an ability to demonstrate that this personal data, this metadata, is it SMS, is it GPS location, is relevant to the data, is relevant to the processing activity in question. So the technology that is deployed, is it suitable, and does it actually collect excessive data, or is actually minimizing the data? So the best practice, of course, from a point of view of legal counsel, DPO, professional advising the company, developer, is that the platform should indeed conduct a purpose limitation test, which purpose limitation is indeed another principle that cuts across all these pieces of legislation. So this means that the collection of this information should be specified, explicit, and for a legitimate purpose, and not incompatible for the first purpose in which it was collected. So maybe the developer can ask themselves, or the company can ask themselves, legal counsel, DPO could ask themselves, maybe instead of collecting the call logs in this scenario, maybe they would want to use mobile money transaction history. If maybe it has been voluntarily provided, we would also analyze consent as a legal basis in this scenario. So even moving on to one of the various legal bases that are provided for under these pieces of legislation, which is consent, I would, more often than not, many professionals, many consumers would think that for every processing activity, the legal basis, or rather, to be very clear, that the legal justification is consent, which might not always be the case. There are other various legal bases for processing. For instance, I know that some companies have trained their AI models using personal data and have based this on legitimate interest. However, the focus today would be on consent based on the example which I had provided. So before I forget, one reference point as well on what the conditions of consent would be has also been highlighted by the Office of the Data Protection Commissioner in its guidance notes. Also, we may also borrow from the EDPB guidelines, which is transpolated from the European Union, which also has more or less similar information to these guidance notes issued by the ODPC. So consent must essentially meet certain conditions. For instance, it has to be freely given. And this element of free, you may ask yourself, what does free means? It implies a real choice for the consumer. So I'm applying for a loan. I get on the platform and this decision would be based on AI. So this element of free implies real choice and control on my part. So as a general rule, these pieces of legislation across the region prescribe that if the data subject, or rather the consumer in simpler terms, have no real choice, and they feel compelled to consent or will endure negative consequences, then this consent is not valid, it's invalid. Yet another condition for consent is that it has to be specific, meaning that the consumer must consent for the processing to each said purpose, and not convoluted or not bulked up. So it must be given in relation to one or more specified purposes. Again, tying into one of the last conditions, which is informed, and also cuts across one principle, which is the information principle, is that it must be informed. By the time the consumer clicks accept to making a decision based on AI, is that they need to be aware. So, and this the requirement that the user must be informed also ties into the principle of transparency, which is also one of the key fundamental principles, which in fact is one of my best principles, because ideally it also ties to all other principles: fairness, lawfulness. So essentially, providing information to these consumers, maybe your in-house counsel, you think about how would these consumers be provided with this information, and are they able to understand what they are agreeing to? And for example, are they able to have the right to withdraw consent? So if the data controller does not, or rather the company or the developer does not provide accessible information, user control becomes illusion. It's an illusion. We've already talked about what is AI in your mother tongue. If the user is not able to understand in Kinyarwanda what decision is being made about them, then this is not transparent to them. If they're not able to understand in Kirundi, in Swahili, then even the access to financial inclusion would not be a conversation at that time, because I imagine maybe I am reaching out to a consumer, maybe in the village somewhere in Kisii, in Changuzo, in wherever. And if they're not able to understand in a language that is understandable to them, then automatically you're not providing this information on how AI would be used to make decisions about them transparently. So the compliance failure here is that, for instance, it would fall short of maybe Section 32 of the Kenyan Data Protection Act if the user does not understand what they are consenting to, especially also in regards to automated decision making. And if this policy is maybe buried in dense legal terminology, you've thrown in legal language, how would your grandmother, how would your mother be able to understand this? So if it only also offers a blanket accept all option and not a specific consent mechanism, then there we see violations of the various privacy laws. So in summary, the organization needs to explain how this artificial intelligence model makes decisions about them. That, for instance, they were not granted this loan for these reasons, and they have maybe appeal mechanisms. And the best question is that if your grandmother would not understand what they just agreed to in maybe Luganda, then it's not valid consent because they would not be able to tick or not consent to. So again, these various laws introduces provisions to protect these consumers, these data subjects against decision-making based solely on automated processing, including profiling. So decisions made on this basis are allowed under certain legal conditions as outlined in these various pieces of legislation. And the reason why I highlighted consent alone is that because consent plays a key role in this protection mechanism, and the legislations make it clear that an organization may proceed with this ADM, automated decision-making, including profiling, that may significantly affect this individual. Say, for example, they are not granted access to this loan. So therefore, or rather they are given this loan based on maybe where they stay. So consent makes up, it's like a cornerstone. So there are various guidelines as well, borrowing from the European Union as well, that have listed out the Working Party 29 guidelines that have produced separate guidelines in relation to making such decisions. But our privacy laws in East Africa state explicitly that users have the right to object to decisions that are made solely on automated decision-making AI, and these are decisions that significantly affect them. So in this scenario that I had given before, the app auto-approves or rejects loans without human review, and therefore offers no appeal mechanism. One of the compliance failures under these pieces of legislation is that there is no human intervention, and best practice requires a request to allow the users to make a request for human intervention. So think about it. You're an internal DPO, you're an external DPO in advisory. You need to advise your client, your organization, your developer that these tools deployed, yes, they want to make loans accessible, promote financial inclusion, but you're deploying AI, users have to be able to request human intervention. You need to be able to provide an explanation to the decision. You need to be able to maintain logs of model behavior for audits. So for example, informing the user that your loan was declined based on maybe your repayment score. You can appeal this decision or request for a review by our credit team. It needs to, the users have to have this option. And then lastly, I would like to highlight one key obligation for such risky processing activities, which is a data protection impact assessment. So data protection impact assessments are carried out when processing activities would highly likely to result in the high risk in the processing, in the rights and freedoms of individuals. So can you imagine being denied a loan based on a decision made without human intervention? This may mean that probably farmer in the village is not able to plant their crops and therefore not able to have income. In this case, this decision, the DPIA, Data Protection Impact Assessment, which is an obligation enshrined under these privacy laws, must be conducted prior to deployment of this tool, or rather enhancement, or rather developing, or rather putting this platform on the market. For instance, under the Kenyan Data Protection Act, it requires 60 days before, before putting it into the market. This way, it would be submitted to the authority, and the authority would review this DPIA and come back with comments on the same. So imagine the platform is launched without assessing the risks to the rights of the users, and even mapping out the flow of data or vendors, and even that maybe it hasn't considered things like maybe would be highlighted by my esteemed panelists, like AI bias, data breaches. So there is, of course, a compliance failure. And I would make a reference point. The ODPC has also produced a guidance note in relation to a DPIA, because going back to our scenario, the app should have identified risks. For instance, there is risk of bias. For instance, you live in a certain village, and because of your geolocation, the app categorizes that you will be unable to pay this loan. So maybe there could be a bias against a certain gender, against rural users. So the platform should have mitigated this bias via maybe considering these principles, etc. And best practice also carrying out a DPIA involves bringing various stakeholders involved, be it legal, be it tech, people who can brainstorm, personnel who can brainstorm on what rights of individuals may be affected in this case. And then, of course, the DPIA should be updated regularly. And it's just the same thing as would you trust an airplane that has been launched without a safety checklist? So in summary, an AI system without a DPIA is no different. We look at the transparency principle. So users, which I have already elaborated quite in depth when I was talking about information, where users need to understand how decisions have been made. So if users are told simply, you don't qualify for a loan, or it means, or rather the algorithmic logic is, it's not clear even to developers itself, then it means even biases exist, for instance, disfavoring users who do not have smartphones or etc. So the compliance gap would be the lack of explainability in the use of AI. And this also has been, this transparency principle is under these privacy laws. And maybe the colleagues would highlight maybe if AI laws would be enacted, this right to explainability would be enshrined, as we see in the EU AI Act as well. So best practice would involve implementing even model explainable tools, also providing user-facing explanation, for instance, that the user is able to understand that the system considers several factors in order to grant or refuse your loan, for instance, repayment history, transaction frequency, and maybe phone usage activity, and that maybe the user is given the option to contact the organization for more information or requesting a manual review. So I think that's it for now. And I mean, some of the challenges is that it's still not clear that privacy laws would be a foundation in order to enhance AI compliance. However, I'll leave it up to my colleagues as well. And in conclusion, I would like to say that AI decisions as well should not feel like magic, because as legal experts, as developers, our role is to pull back the curtain and ensure that AI serves the people and not just for profit. So there has to be an element of compliance. And the idea is that these laws are not here to hinder innovation, but rather to consider the risks involved in this regard. So I think I would leave it as at here, and I would be happy to hear what my esteemed panelists would have to share. So thank you so much, Fabiola. I would leave it up to you as at this point. Thank you.
Thank you so much for the insights. You've really pulled the curtains, and you've showed us how there are people behind making sure there are laws that make sure that people understand what is going on before they give their informed consent. I like the fact that you emphasized on accessibility of the language, on transparency, and making sure that there's a human in the loop in case there's a need of intervention, and there's also room for appeal. So as far as the legal legislations are concerned, it sounds like there's at least the willingness to ensure that the people's rights are respected as these innovation evolve. I would like to hear from our second speaker, Dorothy Ndazi, who is a partner and head of TMT at the Hilton Law Group. We just heard how national laws and especially on privacy, making sure that there's accountability when it comes to deployment of AI, of these AI tools. We would like you to discuss on the cross-border data transfers. So what are the strategies should entities adopt to navigate cross-border data transfers within the East African community, especially given that we have different laws on privacy and data protection. There's also the East African Community Digital Economy Blueprint. Do you think there is a way we can use this to support the harmonization and enable responsible AI deployment across the borders?
Yes, thank you so much for the opportunity. So I might need to share a few slides as I'm going to navigate on this. What should we do in cross-border data transfer, in particular in East Africa? As the previous speaker already said, like we have different laws of data protection. And when it comes to cross-border data transfer, it is not as easy. In the Tanzanian laws, the commission is first with a lot of authority to determine whether the cross-border data is done or it's not done. And I'm sure it's the same to most of other jurisdictions. So yes, we have a challenge in cross-border data transfer, especially with the now rising the rise of the digital economy and the use of AI, which is vast from the fintechs to agricultural solutions to everything. So it's like now it's the way of life that we have right now. So allow me to share a few slides. Can you see? I hope we can see.
Yeah, I can see on my side.
All right. So the good thing is we've already discussed about the diverse legal frameworks that exist regionally and regulatory challenges for AI systems, which face hurdles due to inconsistent data governance and legal fragmentation, and also complexities of cross-border data transfer due to the need for permission, which varies from place to place, like from jurisdiction to jurisdiction. And when we come to the legal approaches for practitioners, what we can do, the first thing is to assess the transfer legality. Like we have to begin with a detailed mapping of the data protection laws in all East African states to ensure compliance. So that is the first thing as a lawyer you're supposed to do before you engage in any data transfer. This is to ensure that you are safe as laws vary from jurisdiction to jurisdiction. Otherwise, you might think that what is applicable in Tanzania is not necessarily applicable in Kenya or in Rwanda. Of course, this includes conducting jurisdiction reviews, extensive reviews of applicable laws on jurisdiction by jurisdiction basis, and of course, identifying sufficient safeguards, like what constitutes of data transfers, like it should be sufficient. And then you need to map the data flows, like whatever data that is.
Sorry to interrupt. People in the comments are asking if you could put this in the presentation mode so it can be more visible.
Oh, it's not in a presentation mode. Sorry. Sure if I can do this. Okay. So the screen is not seen.
We are seeing the screen, but it's tiny. It's not readable. If you could put it in the slide format, but it's okay. We can share the slides later.
All right.
Or you can just zoom in. Yeah. Thank you. Yeah, this is slightly.
This one is visible, right?
Yeah.
So there are contractual safeguards and privacy by design as the first things that can be done to ensure data protection through tailored agreements and proactive privacy assessments in AI deployments. And when you're talking about contractual safeguards, we're talking about when drafting contracts that involve data transfer, make sure that you have we have custom clauses or data processing agreements that clarify data handling, data retention, the cross-border flows, the clauses on data security, on breach notification, and audit rights. Since they're different in different jurisdictions, the best way to go about it is to make sure that in the contract you safeguard this and they are clearly stipulated. And then on the privacy by design, as we know, you need to conduct data protection impact assessment, as the previous speaker talked about, and to identify the risk before and after the transfer, so as to ensure that data minimization is in account, is taken into account. There is purpose limitation, and there is lawful processing, like in every stage of your AI deployment. So these are the first two tools that are very important for lawyers to look at when doing the data, the cross-border data transfer. And also risk assessment and due diligence before any transfer. Like I said before, you need to do impact assessment to know the legal risks in the destination country and to analyze the security posture. I've spoken about this before. And then there is cloud vendor compliance. This is adherence to standards of vendors and data center jurisdictions, certifications, regulatory alignment. So this is also very important when you're doing cross-border data transfer. You have to make sure that whoever is doing the deployment of the AI tools, they are compliant. Also, we need to educate clients on consent requirements. I cannot speak much on the consent because the previous speaker spoke very well about consent and how it's supposed to be. So data subjects are supposed to consent on their data being transferred from to other countries. Also, we need to adapt interoperable compliance mechanisms that are navigating divergent national laws through effective frameworks. So these include standard contractual clauses that are customized to reflect national nuances, and then you have cross-border privacy rules, including voluntary enforceable codes of conduct being employed by some of the African countries, and code of conduct and certification mechanism, like to provide accountability for data processors who are operating across across borders. As we know, we have different jurisdictions. So if you have certified data processors and data controllers, this ensures that data, as much as it's going across the region, it is safe. So another thing is a very important tool that is a need for regional cohesion. And here we will speak more on the East Africa Digital Economy Blueprint, which is a framework that promotes for cross-border data governance and harmonization. And this was in place in 2020, and it's a very important tool to ensure that we have harmonized data transfer across the region. And there are some pillars which are very important. If we take them into account, they will help us as we're navigating this cross-border data transfer, such as digital infrastructures that encourages cloud hosting and data centers and harmonized spectrum use, broadband policies, and national ICT strategies. Then you have things like digital government, which promotes the PPPs for cross-border data use cases and build interoperable public platforms with consistent data transfer protocols. And you have digital skills and innovation. This includes like to start from in the universities or education levels where AI is incorporated in the curricula. And for Tanzania, I think we already have the national strategy for AI, national policy for AI for education. And then you have policy, legal, and regulatory frameworks that are to create a digital tool for cross-border compliance and maybe establish East Africa Data Protection Council for standard setting and dispute resolution. So the EAC, East African Countries Digital Economy Blueprint, has pretty much tried to see how we can harmonize the laws and ensure that the cross-border data transfers are smooth. And of course, we need to have mutual recognition of regimes and development of adequacy standards and trust framework for digital services across the region. So pretty much the digital economy blueprint calls for interoperable legal frameworks. Like we have legal frameworks that can easily relate at some point, and then common cybersecurity protocols and a regional trust framework for digital services. So as lawyers, we need to align strategies with these goals and advocate for legal convergence within the region. And key takeaways that I can say is we need to start thinking regionally as legal strategies are now need to move beyond national compliance to regional compliance. As we all know, if you're talking about artificial intelligence, like you're not counting on the geographical boundaries. So we need to think as a region how we can have legal strategies so as to move beyond the national compliance and we move to regional coherence. And then we need to balance flexibility and safeguards, support innovation, but at the same time, maintaining consumer protection and collaborate cross-sectorally, like engage with tech firms, regulators, and civil societies. Because if we as lawyers are just confined in our legal fields, we don't engage with the tech firms, which are actually producing the deployed, the AI deployed every day, or maybe the regulators who are making the policies, the civil societies who are also working to make sure that the consumers are protected. We might not reach where we're supposed to reach, and it can be a bit more difficult. So this will highly help us to improve and to leverage up in this cross-border data transfer. And of course, we need to anticipate change, like we need to stay ahead with continuous legal updates. AI and technology, they're things which are moving very fast. What we know today might not be the case tomorrow. So as lawyers, we need to stay ahead with continuous legal updates to know what is going on, what is happening in what region, so as you are updated, and when advising a client or when in any role as a lawyer that you're doing, you're not facing any challenges. So we cannot say that, cross-border data governance will define the region's digital sovereignty, because if it is unified, there will be trust economy, there will be integration success, and as lawyers, we need to lead this with expertise and collaborations, and we need to be the change in the AI governance by making sure that we practice the best, we practice the best practices in ensuring that the cross-border data transfers are smooth, protect the consumers, and in alignment with the laws in different jurisdictions that we're in. Thank you.
Thank you so much, Dorothy. I feel like you're giving us hope. On the ground, you can see that some leaders or some practices show that there's no harmonization yet, but I guess we can rely on the lawyers to bring this harmonization and make sure that we at least like agree that we are in this together, and data sovereignty can be regional. We can share the data and bring innovation. And
Yes.
yeah,
exactly. As much as it looks like there is no harmonization, but still, since it's something that is new with other countries that do not have the data protections laws yet, we still have a room to make sure that at least we create a regional tool that can ensure that the flow is smooth across the region. And of course, this blueprint, if we really, as countries, take it seriously, it has some of the solutions which can be useful really to ensure that the flow of the data across the region is smooth. Yes.
Nice. Building on what you just said, I would like to welcome Mr. Quincy Otieno. We would like to hear from you how these privacy laws contribute to ethical AI deployment, particularly when it comes to addressing the biases in these AI systems, how to ensure transparency, how these laws can be used to ensure platform accountability. I would also like to hear your insights on the Kenya AI policy. And I've seen that many countries have adopted AI policies, but are yet to enact laws regulating AI. I've always been curious how, like, is it okay that we have AI policies and not laws? Should we rush to regulate AI through the laws? What is your take on that? Thank you.
So, thank you. Can you see my presentation? Because I want to make it as entertaining as possible.
Yes, it is. It is.
So, let's begin by an anecdote. Whenever we have a conversation around AI governance within the chambers over here in particular, the clerk always has a joke, and he starts by asking us, what is this AI and how are we going to, what framework are we going to use? Because he says there are a lot, but you do understand the one thing that he always encourages us to do is to look at the data governance field. And I'm happy that at least today, there's a policy workshop which I'm doing concurrently with this, and we're training people on AI policy development by Tech Hive Policy. So let's begin today's discussion, especially on AI. So many lawyers normally ask me, how or what do we use to create policies, strategies when it comes to AI governance in context with the East African community. Don't forget, it just depends on where we begin this particular conversation. What level of the pipeline, or at what juncture of the AI development cycle are we going to regulate? Are we going to introduce rules and regulations? We have a lot of information asymmetry. We have a lot of foreign tech firms which are in Kenya, foreign tech firms within East Africa. Kenya has a famous company called, the Meta. Meta as the company is within Kenya and has been times above numbers warned that stop exploiting the gig economy workers when it comes to them doing content moderation, flagging particular content, and always sitting down and being the eyes before using that particular data to train particular models. This kind of asymmetry, power asymmetry, shows that indeed our labor laws are very weak. And from the pipeline, we'll start with the human within the loop. And in this particular instance, we'll start with the gig economy workers, particularly the data labelers and annotators, which in Kenya right now, they have a society. Don't forget, from the inherent or from the start point, no AI system is neutral. There's always a form of bias. And I'll make reference to Joy Bulaiwami's book called Coded Bias, where her research showed consistently under an AI system which dealt with a particular facet called computer vision. It was used to train cars, specifically the Tesla models, in how to do something called automated driving. In order for that particular system to work, it needed to be trained on a particular data set. And in this case, it was the facial expression of the facial output. However, there was one underpinning issue. Majority of coded libraries under their guidance notes usually have like a bias monitor or a form of bias indicator. And for Joy Bulaiwami in her book, she said that darker skin tones were not really recognized or not really picked up by the autonomous systems. And if you translate this into real life, you'll find that we will have vehicles, in case we have full automated driving vehicles within the East African context, they would kill a lot of road users. And they would not be able to pinpoint that indeed there are road users within this particular text. If we switch this now to AI systems now in a particular set, the reason why I still insist on bias is because the algorithm normally picks up what was inherently used to train it with, which is this particular data set. This data set, as at the moment which it was picked up, cannot differentiate what is right from wrong unless we feed it a form of parameters which shows us that indeed these are the connotations, these are the boundaries within which you operate. Mm-hmm. Following this, if I was to take something as simple as the Swahili language, the enunciation and the pronunciation within our East African community is different per se. So when you are training these models on perhaps to recognize Swahili connotations or terminologies, interpretation in terms of context maybe between Tanzania, Kenya, and Uganda, or Burundi, or Rwanda will be different. And this kind of difference is what we deem as data bias within the digital infrastructure of the algorithm. Now, there are a lot of challenges, particularly when it comes to this issue. And for policymakers world over, especially if I'm to narrow down to within the African context, you will have to realize that whenever we train AI models, we are heavily reliant, especially the large language models, they're heavily reliant on global North data sets. Why? Because for them, it is easy to acquire, to train, and it is easy to give out output when it comes to this particular data infrastructure. Simply put, there is no form of reparations framework within Africa. Now, we have on the presentation bullet points which I wanted to note, which I hope from my analogy it has been brought out. And the reason why I highlighted all this for is because it summarizes the areas of focus which all lawyers need to look at, because behind each and every one of these points, there's at least a legislative framework which you can use or which you can modify to compensate for the lack of a tailor-made specific legislation. Labor exploitation is there. Summer source, which is really popular in Kenya to outsource labor, has been in gross violation of a lot of these terms and conditions. If you want to find out more about what they're doing, there is an active court case which is currently ongoing within the Kenyan law courts, which will further expand on this. And I'd be happy to leave the link below. Now, onto the second slide. We have a lot of challenges when it comes to the AI governance frameworks. And I'll start by something I call regulatory fragmentation. Simply put, if I look at AI governance as a whole, at the base of it is data. In East Africa, happily enough, we have data legislation, which is there. But however, it only focuses on personal data, personal information. The crux of this is that not every single data that is used to train these models will fall under the data, will fall under the data legislation. A lot of it will fall under the data governance guys, because some of this data cannot be openly interpreted, which forms a very big issue as to who gets to decide what data is used, number one. Is there a framework which is going to be used to compensate in case this particular data is used? And number three, in cases indigenous knowledge, as it is termed, how are we going to make sure that the right and accurate information is there? If there's that form of chartered map, then we can have a good conversation about let's now govern the AI system. However, outside this realm, we have AI strategies. At least in Africa or world over there, it's a wide known conversation. Within Africa, we only have 6 countries so far which have got a proper AI strategy. It articulates ethical principles, defines enforcement mechanism, future legislation. However, there's a regulatory vacuum per se. This is particular to the Kenyan national AI strategy. Who is going to regulate this is part of a bigger conversation. And there's a huge conversation right now about having a cross-functional team between the legal, technical, and the governance realms as to who will be involved within those regulatory bodies which will be formed or which will be amended to include this particular one. Now, within Uganda, we have the Uganda Transactions Act, and it lacks the provisions for something called algorithmic accountability or transparency, which falls under, for me, my base information, my base guideline is always the OECD AI guidelines. The reason why I use this is because they're universal and they're ever-changing. It's not implied that we can't come up with ours, but as at now, it forms a good guide. Within Tanzania, the Cybersecurity Act will prioritize security over individual data rights. However, it limiting protection against surveillance and misuse. So this particular acts which I looked at have an ideology of how they can mention algorithmic governance or AI governance in this case. The problem of it is that we have more texts which comes outside the African continent rather than inside the African continent. And the crux of this is that we can't always lean on the Brussels effect of always having something that is formed outside the continent, then it comes inside. The main challenge of this is with our diverse data sets and our ethical pathways for different regions, if we have a blanket regulatory direction which stems from the EU or from the UK, it will be a bit too challenging because it does not simply capture the diverse nature of the data sets which are going to be used to train this particular system for particular use cases within Africa. Now, within this particular challenge, there were legal gaps, and I'll implore everyone to take a look at, there were case laws which were normally floated around, which formed good basis for algorithmic accountability and redress. There was one, which was the Vodacom Tanzania data leak, and they had a legal gap and then they had a human impact. So for the legal gap for this one, there was no mandatory breach notification laws, which is quite cumbersome because in case your data has been leaked, how are we going to notify? In terms of response, how fast are you going to respond? And I'm certain Wendy over here would happily tell us day over that in case there's an emergency and there's a data leak, your first 24 hours or your response time is usually very important as to how you're going to address and redress this. The human impact of this was one user was sued for about $4.3 million of unauthorized AI data sharing. I'll share the case law after this. I'm certain a lot of all the lawyers would like to find out what the court will rule or what the court has ruled. Now, within Kenya, we have a lot of bank finance institutions which are using AI systems for credit scoring, per se. Absa Bank recently launched or partnered with Akili AI to solve this. But the one thing that I challenged them was, in case a customer or an applicant is systemically denied credit, what is the appeals process they are allowed to redress this? Because don't forget, you have the right to challenge a particular automated decision-making process, which is a proviso in all the East African Data Protection Acts, as to the right, with reference to Kenya, the right to refusal for automated individual decision-making. Now, when it comes to something called bias audit will fall under two paradigms. One, we'll have one under an ISO or a PCB certification, which will depend what AI have you onboarded. For the legal practitioners, what this will mean is that when there's a standard prescribed, the duty of care is what you will, the duty of care is what you will establish as to who has a fiduciary duty under who. If, as a bank, you do not disclose that indeed you have onboarded an AI system to help you with particular process at particular steps, you are begging for a lawsuit and you're begging to be sued. It's very important for you to disclose this from the onset, and each and every one of the users or customers either has to accept or reject, because they have the right to do so under various data protection legislation. I would urge you to look at Hume Masahane. It's a software, it's an AI in South Africa, and they have a benefits sharing agreement, which normally, like, it empowers communities to claim rights and benefits over their data, and it challenges the exploitative extraction of foreign firms, particularly when it comes to training of artificial intelligence systems. Now, we have something called the infrastructure tax paradox. A lot of digital services within East Africa have value-added tax, particularly on internet devices. It will depend on, I believe, it will depend on the nation, particularly when I look at Kenya and Uganda. Some vary from 15 to 20%. However, large investments like Microsoft have always had like an AI initiative pumping about $1 billion across the region. But this is criticized as being a bit too neo-colonial, as the need to tax by government and the need to invest is kind of pulling the strain on innovation and leveraging. The reason why I thought this was very important, lawyers now, when you are developing a policy or when you're developing a guideline or guidance notes, you will have to look at the tax regimes, because a lot of these platforms or a lot of people within this segment are going to rotate or operate within the digital realm. Digital realm is indicative of you having access to internet. Majority of policymakers have had conversation about how to regulate AI or which AI governance track to use. Kenya, we had our first motion last week by Honorable Marianne Ketan, who was floating an idea of how to regulate AI. However, the question that we simply asked is, at what juncture are we going to start regulation? At what juncture is regulation paramount? Because if we over-regulate, it's going to lead to regulatory capture. So legal practitioners within this particular forum, I urge you to have a conversation and always granulate it at the juncture where we need to have guidelines as to what are we regulating within the AI development cycle. Are we regulating the workers, the data in particular, the system in particular, the sandbox, which if you're privy to the black box conversations, there's now a new term which is called a glass box system. And this glass box will simply bring out the need for us to have the transparency. The term glass was coined figuratively to enunciate or to bring out the fact that we need to know in this decision tree, if I am told to cross-examine a developer on this decision tree, and I asked him, did the particular system churn the expected result according to the parameters fed? And is it possible to guide it? That is the conversation around the policy and around the framework which we ought to build it. Pathways, in terms of pathways to, sorry, let me just scroll a bit. Yeah, in terms of pathways for legal practitioners, the first one I'd urge is let's harmonize, or let's have a form of harmonized regulation across East Africa. The Malabo Convention is a very good place to begin. Although not binding, it provides structure. African Union as a whole has a very weighted task, because what I'd recommend is we can use the risk classification systems of AI from the EU AI Act. However, we'd have to define risk according to how we want to see it. Secondly, it's very important that when we're defining risk, what facets within the African jurisdiction are we going to operate under? By this, I mean, not every chatbot or not every healthcare diagnostics is going to mirror the same. Unless it's universally accepted, there are some systems or there are some cadres within society which are going to require different or less stringent use case or classification within AI. And it's something which we need to address from the onset. Now, data sovereignty has been talked about. The only thing I'd add is, how about we scrap a lot of licenses? We have a tendency of overregulation, and I'll give you some example. Kenya launched something called the Diplomat's Playbook, which required foreign firms and licenses to license social media data through national data trusts, local control, and benefit sharing. What's the need of all this panic response into having licenses? If it's a means to raise enough funds, then there are better ways of doing this rather than just issuing licenses, because it feels like an all-colonial playbook around the particular conversation. So there was one conversation which I was having earlier today. It was, how do we legislate AI explainability? So there's this term we call local interoperable model agnostic explanations and sharp addictive explanations. So it just means, can we have meaningful information right for automated decisions? Meaning within that automated decision-making process, can I have a glass box system which can explain to me that, yes, I did feed my data as Quincy. My data has gone through this system and is used to curate me for the new generation ID or driving licenses. Beyond that, I would need to look at your DPIA if you're going to further process this. In terms of DPIAs, there's a limitation to it when it comes to AI governance, meaning it only focuses on a singular level of processing. And if you're aware of black box mechanisms, there are further levels of processing which are not enunciated within any data protection legislation. If we are to build capacity in this sense, we would have to come up with other impact assessments which would be relevant to this. There are a ton, from ethical impact assessments, human rights impact assessments, artificial intelligence impact assessment. But for me, the one that stands out is something called algorithmic impact assessment, because it would help me as a legislator or a policymaker to know at what particular levels of this particular system using my data is it going to process. And this particular algorithm, what is its end purpose when it comes to processing? Because now it ties down for every DPIA, and an algorithmic impact assessment would accompany it. Meaning I would know where my data is going, then I would know how the algorithm will affect that data. However, there's a caveat. The question I'd pose is, at every single stage, will we require multiple DPIAs for every level of processing, or how will we amend, or how will we adapt the current DPIAs to factor this in? I'll share this particular slide, or this particular guidance note which I prepared. But to key it off, we have the AU Continental Strategy, endorsed in last year, July. So there is Agenda 2063, and there is the African Continental AI Strategy. For every country or every lawyer who wants to get involved in the AI policy, governance, framework, and alignment, we start from the top, or granulated all the way to our different jurisdictions. In trying to come up with legislation or ways of regulating AI or AI governance, it's very important for us to have strategic priority, which if you look at the SDGs and Agenda 2063, you'll find them. Under the continental AI strategy, harmonized AI governance framework would really help, regionally speaking, because if we have ethical guidelines and sovereign ecosystems which are particular to East Africa, it would make it easy for us to have incidences where, as market leaders, your AI system can work in Kenya, and then can also work in Uganda, can work in Burundi, can work in Somalia, can work in Ethiopia. Additionally, in the quest for investment in digital infrastructure, we need to have data centers within a particular context. It would really help from the onset that cross-border data flows or cross-border data governance issues would be tackled from the onset, so that in case we have data centers maybe stationed in Uganda, a data localization requirement would not act as an impediment to a unified AI governance framework. It would rather encourage it to be developed and to be deployed within that particular context. Lastly, the last two, which I think is very important, is capacity building for AI research and policy. We have a lot of think tanks which are leading this. However, there needs to come one from even the legal fraternity. I think it's commendable that a lot of research which is being undertaken on the governance spectrum are being led by lawyers across board. I've interacted with quite a lot of them from Tanzania, from Kenya, from Uganda, and there's particularly one called Ridwan from Nigeria who's currently featuring really well when it comes to research. Context-specific research is very important. Having a form of stakeholder engagement from different countries is equally important. And then don't forget, research cannot act in a silo. Whenever we're researching about AI governance, there's going to be new developments which are going to be there within their particular AI governance framework in the technical capacity. An example is Apple recently released a book, an academic paper, which demystified the whole capacity of large reasoning models. And governing this is going to be particularly challenging because whatever was broken down or floated as a reasoning model did not meet the pre-requirement of a technical underpinning of what is a reasoning model and what is a language model. That's very important. Also, agentic AI systems are going to be a huge conversation when it comes to AI governance. Lastly, we're going to need protection of data sovereignty and promotion of culturally relevant AI systems. When I insist on having AI systems that are cognizant of cultural diversity of Africa, it's because within the African continent, we have more than 54 languages which are spoken. Most of these won't be factored in. Most of these are personal data or rich data which will be used to train particular models. So how can we ensure that if we have these systems, they can translate well across board, meaning I can use them in different contexts without worrying about compliance within those particular countries? In its phased approach, the AU AI strategy will focus initially on governance frameworks and capacity building, which is going to be important. So as a parting shot, we have to have Africa's AI governance system built by design and not by default. It's our task to make sure that we enforce a code and ensure that the algorithms that are going to be used serve as justice and does not extract it from us. Alternatively, it means we'll cede our digital sovereignty to platforms that see East Africa as a mining rig or as a quarry. Thank you very much.
Thank you so much for the insightful presentation. And I love the fact that you've brought us back to reality, to all the issues that we are facing as most of the African countries, the gaps and the challenges. I would like to hear from, also I would like to thank you for what you're doing. And you give a shout out to Ridwan. You're really doing amazing work in training and making all these regulations and policies available at Tech Hive Advisory. So thank you. Next, we would like to welcome Doreen Wanjiru, who is the Principal Data Protection Officer at the Office of the Data Protection Commissioner in Kenya. Otieno has given us, has talked about some of the the case laws and you know the Meta and Summer suit in Kenya on content moderators who have been treated unfairly. We've had other case laws in Tanzania, the Vodacom one. I would like to hear more from you. Please tell us how the AI-driven privacy breaches have been addressed through litigations. Are there dispute resolution mechanisms being used in addressing this issues and breach of privacy? And what are the trends emerging in this space? Can you please share some of the notorious cases and tell us how more legal practitioners can step in to make sure that people's rights are protected, and if they want to sue, where do they go? And yeah, please share with us more on what is going on in the litigation field.
Okay. Thank you very much, Fabiola. Let me put this in presentation mode. Just a minute. Okay, so I will be discussing litigation and dispute resolution in AI privacy breaches. So I like to think about litigation and dispute resolution and compliance as two sides of the same coin, in that compliance issues would give rise to a lot of litigation and dispute resolution issues. So AI privacy litigation is fundamentally built on the Bill of Rights, and it's also as captured in most of in all of our constitutions and data protection, and cascaded in our data protection laws as well as international instruments. On a technical level, I think for us to discuss litigation, it is important to understand basic components of an AI system. We have data, because vast amounts of data are the raw material that powers an AI system. So that is what helps predictions. And the more the data, the more accurate the predictions. So all data is not our concern in privacy litigation. We are more concerned with personal data, which is defined as information related to an identified or an identifiable natural person. So that is the data that concerns us in privacy litigation, and not necessarily all data, as was highlighted by Quincy. We also have algorithms, which are the rules or the instructions on how this data should be processed. Say you're using a GPT, you give an instruction, the rules that the system will use to interpret that instruction, that is the algorithm. And then we have the computing power, which now acts as the engine that drives large-scale processing. So understanding this architecture is vital as AI continues to penetrate key sectors. We have seen it being used in finance, as has been highlighted by the panelists. It's being used in agriculture, in weather predictions, it's used in education, and now even in public administration. So the litigation trends that we have seen in relation to AI privacy breaches, as I said, compliance gives rise, lack of compliance rather, would give rise to a lot of litigation. So one of the issues that is coming out strongly is a lawful basis. Consent has been discussed. The issue, for some reason, developers of AI systems like to rely on consent, despite the fact that consent has a lot of conditions, and this has been highlighted even in litigation in Kenya, particularly. It was highlighted in Tools for Humanity, where consent was incentivized with a monetary compensation, and therefore it was seen to not have met the conditions of consent. So while it is very common, it is very difficult to demonstrate in privacy law. The linguistic diversity of this region has been discussed. because it's very difficult for different individuals to understand, say, consent notices in English or Swahili. Depending on your region, it will vary. Therefore, demonstrating informed consent that has been given on, say, giving an example of Kenya, say Kiswahili varies in street Kiswahili, official Kiswahili varies. So demonstrating informed consent in that aspect is very difficult. We also have the difficulty of the long, complex privacy notices. I'm sure we've all been fallen victim to opening a consent notice, say for a platform that you're using, and once you see how long the consent notice is, or the technical language that is used, you just go and tick the box. So that consent fatigue also leads to the lack of proper consent being issued. So these are some of the issues that come up due to reliance on consent. And so consent is likely to raise a lot of litigation issues. There are so many other lawful bases that could be used by developers of AI systems. We have contract performance, legal obligation, we have vital and public interests, legitimate interests, and those would be stronger lawful bases and lead to even less litigation. Another trend we have seen is on AI transparency and explainability. This has been discussed by my colleagues. There's a black box and gray box problem. Technically it's okay. So in simple terms, it means that there is a need for clear and continuous disclosures throughout an AI life cycle. So from the collection of the data to the deployment to the use, there needs to be explainability for everything that is being, for how the data is being collected first, how it is being used, how it is being processed, how the system is being deployed, how it's being stored. So there needs to be full explainability of this. And when there is lack of this explainability, then it offends the principles of data protection. This is lawfulness, fairness, transparency, purpose limitation, data minimization, accuracy, storage limitation, integrity and confidentiality, and my apologies. And also it also offends the rights of a data subject. So you have the right to be informed. When an AI system does not have explainability, then it does not allow you to be informed on how your data is being used and how it's being stored and so forth. You do not have the right to rectification, to erasure, to restrict processing, object, data portability, against decisions, the right against decisions made solely on automated processing. So you're not able to exercise your rights because there is truly no explanation as to how your data is being used. And so this issue will raise a lot of litigation issues that we expect to see. Next, we do have data protection impact assessments. Sorry
to interrupt. People in the comments are saying that the slides are not moving, and not that it matters. You're doing a great job explaining.
Are you able to see them? Are yours moving?
We can see the introductory slide, but not the other ones.
Let me just. I don't know if you're able to see them now. Are you able to see them?
Yes, now.
When they're not on on presenter mode, anyway. So the data protection impact assessments, we have had the presenters talk about the importance of data protection impact assessments as they help developers while deploying high-risk AI solutions. So they would be able to assess the risks that would be associated with an AI system being deployed and put in mitigation strategies. So courts in Kenya have made decisions on data protection impact assessments, although not particularly in AI systems. The courts have have really emphasized on the importance of carrying out a data protection impact assessments. These are some of the cases in which courts have declared themselves on. And I think this is now the jurisprudence that is currently in place on the same. So next, we have the cross-border nature of AI. So because AI systems operate across borders, litigation is now going to call upon transnational and cross-jurisdictional approach. So say, because there are certain systems that say we'll be collecting data in one jurisdiction, processing the data in another one, storing the data in another one. If you're going to litigate against a company like that, then you need to be in touch with how all these jurisdictions, what the provisions are in these jurisdictions. As highlighted by Quincy, we have a fragmented approach to AI and even data governance, generally, even in this region alone. And therefore, it calls upon practitioners to be versed in data protection principles and laws around each and every jurisdiction. And so that is, I think it's calling, it is a lot. And therefore, it is important that harmonization comes to play in terms of that. So I just wanted to highlight some examples of litigation triggers in AI privacy litigation, and that would be like, say, there's no lawful basis for data collection, or the lawful basis is inadequate. Say the consent was not obtained or was improperly structured if you're relying on consent. Remember, consent may be the weakest lawful basis for one to rely on, because it is hard to prove, hard to demonstrate. Another litigation trigger would be data misuse. How is that data being used? Is it only being used for the, in accordance with the principles, for the purpose for which it was collected and stored for only when required? So data misuse could be another trigger for litigation. There's also the opaque data practices. Remember, ethically, it is important for explainability of AI systems and what they're doing with the data. So opaque data practices will definitely trigger litigation. There's also failure to explain or justify algorithmic decisions. Remember when Wendy gave her example of how of credit and financial lending and how you're being scored. So is there a human involved in making an automated decision? Say the data protection laws require that there be human intervention where an automated system is being used for profiling, say in credit scoring, in financials, whatever you're using it for. There needs to be a human in the process. So where there lacks to be human intervention, then that would be a litigation trigger. Also, where there are personal breaches resulting in from poor data governance, that would also trigger litigation. The Data Protection Act requires that data breaches be reported to the ODPC, and therefore, if one feels like such breach was as a result of data governance, there are mechanisms in place on how you can lodge a complaint on the same. So these are examples of litigation triggers. This by no means exhausts litigation triggers, owing to the fact that AI is an evolving space like any other emerging technology, and therefore there will be new litigation triggers. I think it is for us as legal practitioners to be versed in the technical aspects of AI in order to kind of understand what those triggers would look like. So I'd also like to discuss the role of ADR in AI privacy conflicts. The Data Protection Act in Kenya, and I believe across all jurisdictions, provide for mediation and conciliation. In Kenya, this is facilitated by the ODPC. The reason for this is to give confidentiality and efficiency in the process. I know that most high-profile, say, companies prefer to go the ADR way in order to safeguard their reputations. So mediation and conciliation is highly encouraged. Arbitration also, it is very common due to the specialization, since you're able to specialize to get an arbitrator that is specialized in the space. Arbitration is very common in big business. And so this ADR may have a bigger role than the courts even, because in this space, since it's new and not really regulated, it's easier for it to be for disputes to be settled in alternative dispute resolution rather than courts, because also remember, not many of our judicial practitioners have been trained in this space. And so that technical knowledge might be a bit lacking. And so specialization is important in this space. So just moving forward, strategic recommendations for practitioners would be to stay technically informed. This being a technical space, you need to have the technical knowledge. Unfortunately, it sometimes is hard for lawyers. I had difficulties at the beginning understanding the different technical fundamentals, but it's very important in order for you to litigate effectively to understand this. Also, it's important to guide early stage compliance and push for privacy by design. As Quincy said, this is a space that needs privacy by design rather than by default. So that means that privacy measures are put in every stage of development of an AI system. And so moving forward, there is less litigation for your clients, since they have instilled privacy principles from beginning to end. Also, the support for regional harmonization, fragmentation of our laws has led to so many difficulties in terms of cross-border data transfers, cross-border litigation. So regional harmonization would be essentially the key to easy compliance. Thank you.
Thank you so much. I like the fact that you gave us an advice to be informed on the technicalities of all these emerging technologies. As lawyers, I can speak for myself. There are some of the technical terms that are so confusing. So I have to Google. Sometimes I have to Google to be able to understand. This has been an insightful conversation. I would like to welcome participants online. Please, if you have some questions, this is your time to ask the panelists. I don't know if Gabrielle Chai can help us. I don't know. Should they ask the questions in the chat, or should we bring them on board to ask the questions? Again, thank you so much to our panelists. We've touched on everything, on AI compliance, on the gaps and challenges in our respective countries, you know, the limited connectivity. I was surprised that the US is at 95% when it comes to internet penetration, whereas we are at 33%. And yet I can say that we have better understanding and better regulations compared to them. At least we have like common understanding, and we are willing to make sure that there is harmonization, even though the Malabo Convention is so far ratified by not even half of the African countries, but we will get there. Without going further, I would like to welcome the people in the audience who have questions. As we wait for the questions, I've read your translations in the comments. The new ones, Masala Bweja in Kisukuma from Tanzania, and there's one in Luo, Rieko Mar Computer. I'm not sure I'm pronouncing it correctly. And there's also Akili Bandia from Tanzania. Thank you. I'm seeing the question. So the question goes, many people use AI and machine learning interchangeably. Do you believe that there is a subtle but important distinction between the two? And what are the implications of that distinction for their responsible governance? This question is not directed to a specific panelist. Quincy, could you please respond to that? The difference between AI and machine learning and whether there's any implication. Okay, so should I read all the questions and you can respond later? Okay. Another question, given AI technologies are evolving fast, won't traditional legislation be too rigid? Another question. Hey, Quincy, kindly share the presentation via email. I think he has already shared the slides in the chat. I will send it to your email. Another question, considering the DPA 2019 and the guidance notes on the education sector, including proposed amendments, what legal and ethical safeguards are needed to protect children from harm caused by AI-driven automated decision-making in education? What role should legal practitioners play in enforcing them? Another question, at the AI level, do we have any law, say East African treaty or protocol that might currently cover the AI area?
Fabiola, on the laws, the main conundrum that you're facing, sorry, let me turn on my camera. The main conundrum that you're facing in terms of regulation is that different countries will have different use cases, and the diverse nature of local use cases of AI is what is leading to a huge disagreement on whether we just want to have penal provisions and we just want to have limitations and control over particular over AI usage. This is case in point, particularly when we look at Kenya, when we had an artificial and intelligence robotics bill, whose crux was that they wanted to create a body whose main aim was to see and particularly vet this particular AI platform systems which are being developed. On the flip side, when I look at the KEBS guidance notes on practice guidance notes on AI, it formed a very good basis for the people who are technically developing AI systems to use or to follow. However, conversation around it still subsided. From what I've seen from the legislative capacity, the crux of it is if we have a regional framework or a regional conversation about AI governance, from what angle do we start? Because it can start as a fragmented as how the intellectual property regimes are, from private to national roots to international conversations. But the thing is, what are we comparing it against? Because if we are alive to it, strategies and policies are well and done. But the question that normally circulates within these particular rooms is that, are we really ready to have hard law encoded to regulate something that's ever evolving? Because on every single conversation we're having, the conversation on AI regulation is evolving landscape. We started with LLMs, now we have large reasoning models, we have agentic systems. The next conversation which we are having right now is quantum artificial intelligence. So are we going to have one law that is capping on the term AI, and then over time we're going to amend? Or are we going to have a policy which will be sector driven, which is often more than not widely accepted? And from which connotation of policy are we going to begin? Are we going to begin by identifying the problem? And the problem and the crux of it at this juncture is, what problem within the AI governance field are we facing? Is it the fragmentation of innovation, or is it the use case of data which is not exactly recognized, or is it the compensation mechanism which we need? So like, that is the crux of what we're trying to solve. Thank you for
that. Another question they asked, if you may respond, it says, given that AI technologies are evolving fast, won't traditional legislation be too rigid?
Yes, I do agree. Traditional legislation will be rigid. The various policy workshops I have been in, the trainers often float a question of, if we have legislation which is hard to amend, what would be beneficial in the long run for developers and the users also to work within? And the main crux, or the main reason for this, is we need to derive value from this particular technology. If we overregulate, it will lead to regulatory capture. So in eventuality, we will have a scenario where we will have laws, yes, but innovation will be heavily stifled. I mean, look at the risk-based approach that the EU is heavily using, in particular to the GDPR and the EU AI Act, where now they're forcing now to roll back on particular provisions because they're deemed too strict or too rigid for innovation. At the end of the day, the question around policy or law development is going to be, is this beneficial in the long run, or is it just a way to curtail and get licenses and fees?
Thank you. Another question, Dorothy, if you may take it. It says, when you talk of step-by-step consent by the users, does this mean that the privacy terms and conditions that are shown once when you're logging in are not enough?
Okay, so when you're talking about consent, consent has to be, first of all, it has to be explicit, it has to be informative, it has to be specific. And in most cases, whatever it is that, I've not seen the question, but I've just heard it, like the one that is shown there, in most cases, it is not enough, because a person usually consents without understanding what they're consenting to, one. And sometimes, in most cases, it's just a very general consent, like you'll be consenting to a lot of things all at once, which is not what the law provides. So what we can say, or what I can say pretty much is, my take is that in most of these programs or these tools or AI apps, most of the consents, they are not proper. A person does not understand what they're consenting to. The consent is too general. The consent is, it involves a lot of things all at once. Let me give an example of a situation that happened in our country here before the central bank intervened. We had a certain, a number of microfinances which were just giving loans through the mobile apps. So you would download the app, and then upon downloading the app, most people consented to their phone book being accessed and to the gallery being accessed without them being aware of what they were doing. So eventually you would find like the the loan, the microfinances, whatever it was, they would call people in the phone books. They will post pictures and whatnot until when the central bank decided now to intervene. And once it intervened, most of them were not properly regulated, as in just a person who accepts, creates an app, and that is it. So right now it is not there. But that is one of an example that shows that most of the people do not understand what they're consenting to. Because if a person understood, they would not agree to their phone book being accessed or to their gallery being accessed and their pictures being all over the place. So yes, whatever it is that is being done right now with most of the developers or most of the apps that we are having is not enough. That is what I can say. And then yes, that is it on that question. That is all I can say on that. But I had something that I wanted to add on what should be done to the policymakers. In the end of the day, currently we have, for ratification, we have the Malabo Convention, and not all East African country members have ratified the convention. So when we're talking about regional harmonization of the laws, yes, there's no law regionally that is regulating artificial intelligence, but what is there already is East African countries. We are not, some of the countries have not ratified. So I would add by saying that we should advocate for making sure that all of the East African countries ratifies them, so that at least we've made a step towards having a regional or eventually national AI proper legal frameworks. Thank you.
That would really be great. Thank you so much, everyone. We have so many questions in the chat, but for the interest of time, we are not going to be able to address all of them. But I would like to welcome the panelists to have a minute and look at them and maybe address them in your respective work and publications. I'm sure that conversations will keep on, we will keep having these discussions as new regulation come, as new technology emerges. So to conclude, I would like to welcome the speakers to say something, closing remarks. And I want you to share your hopes. What is your hope for East Africa when it comes to data privacy and protection and AI compliance and governance? What would you like to see in the future? We will start with Wendy, then Doreen, then Dorothy, and then we will close with Otieno. Thank you.
Thank you, Fabiola. So I think also just to pick in a few, just to pick in a few questions, one or two questions that have not been addressed in the chat. I think one participant had asked which East African countries have not enacted the laws. I think maybe my participants can chip in, but I'm not aware of any laws in Burundi, as well as DRC, Djibouti, and Eritrea. So far, I know of Kenya that have enacted, of course, Kenya, Uganda, Rwanda, Tanzania, and now Somalia. Also, just to touch in on one question, I think asked by Mina, who had touched on whether considering the Data Protection Act of Kenya and the guidance notes, including what are the legal and ethical safeguards that are rooted towards protection of children, especially in relation to the harms caused by AI-driven automated decision-making in education. So just to regurgitate what I had previously mentioned, that under cutting across all privacy laws, protecting children from harm caused by AI-driven automated decision-making requires a combination of legal safeguards as well as ethical principles, and the legal safeguards relate to the rights, for instance, not to be subject to automated decision making, except where there are explicit safeguards, for instance, explicit consent, and given bearing in mind that children are a vulnerable individuals, the conditions for consent for children have to apply. For instance, for Kenya, parental consent would apply up to the age of 18. So in general, there is a special protection for children, both from the legal perspective as well as from the ethical perspective. And just to give a parting shot, and this I have discussed as well with other privacy professionals, including my colleagues, that data protection laws are the key pillars of AI governance. And this is particularly even applicable, not within our context, but in the EU context, because the EU AI Act is more of a product regulation than a rights-based framework. So, and in general, what I would envision for the East African region, what I would see to be fruitful is more cooperation between especially supervisory authority, given cross-border or rather data processing activities. It would be an interesting opportunity to see that supervisory authorities issue decisions in cooperation, especially where processing activities cut across data subjects that are located in various countries. So this we have seen as well within the EU jurisdiction, where supervisory authorities come together and cooperate towards issuing a decision. So thank you so much, Fabiola. I would let my panelists have a chance to give their parting shot, and thank you so much for with the engagement. Thank you.
Okay. Thank you so much for this engagement. My parting shot is that I look forward to Africans being able to build our own AI systems that are built on African data sets. Indigenous AI systems that are built here are crucial to solving African problems, and therefore I think that it is time for us to build our own. We are now depending on AI systems that are built on data from the global north, which is not really beneficial to us as it is not solving our own problems. And so what I'm looking forward to is more innovation in the field. So thank you so much for having me in this session.
As for me, I think the journey towards digitally integrated and AI empowered East Africa has started, and it starts with small forward-looking legal strategies. So we should not be threatened by the cross-border data flows, as most laws are put in such a way like it is a threat, but it is an opportunity, provided that we manage them with care. There's consistency, there is cooperation, and as lawyers, we need to lead the change in designing the regulatory frameworks that will make sure that we have a smooth flow of data across the region. Thank you so much.
Otieno?
So, embrace AI. People ought to be trained in terms of AI governance, risks, and alignment. We ought to have a real conversation about alignment, because I feel like everyone seems to understand the buzzword AI governance, but the alignment bit is very important when it comes to now having an ecosystem where now the tech community can now consult the governance system and the governance community. And equally, we could have a big conversation as to how now, regionally speaking, we can have a framework which we can now use as bare bones when it comes to AI governance. And to answer Elizabeth's question, I do training at Paradigm Synergy Enterprises. I do provide training for governance, safety, and upskilling when it comes to these particular divisions. Please hit me up on LinkedIn. I will answer to all your questions and queries regarding governance and I would train anyone who would be interested in that particular system. Others, thank you very much.
Thank you so much, everyone. Thank you to our audience for your participation and engagement. We look forward to continued dialogue and collaboration across the region.
Well, thank you so much, Fabiola, and our esteemed panelists. It's indeed been a pleasure to host you this afternoon and accept our sincere appreciations, Fabiola, for one, allowing to facilitate this session, but also for waking up quite early in the morning and devoting your day towards having this conversation presented. A special vote of thanks to you, to our esteemed panelists, Ms. Doreen Wanjeru, Doros Ndazi, Mr. Quincy Otieno, and Ms. Wendy Kuyo for sharing your expertise and knowledge with us. We greatly value whatever you've shared with us, and we are greatly indebted to you. Thank you so much. We also appreciate our participants. Thank you for showing up in your usual big numbers. We appreciate your constant support and look forward to your participation in our forthcoming sessions. And as it's been announced, the East Africa Law Society will be conducting its annual law conference in Addis Ababa in November this year. So you want to register for that conference where such discussions of this nature will be taking place physically with a broader number of people. Would like to invite you to our in-house council convention that will happen on the 28th and 29th of August 2025 in Kigali, Rwanda. Please register for the session if you have not. It doesn't matter whether you're not in-house, as long as you are a private practitioner and you're a lawyer. And please register for the conversation. We'll be in Kigali, Rwanda on the 28th and 29th of August for the in-house council convention. So it's an
I would like to thank everyone. This marks the end of our insightful conversation. We look forward to welcome you in other discussions. And to our speakers, thank you so much for making time and for sharing your expertise and for agreeing to respond to some of the questions in your other free time. So, Mubarikiwe. See you next time.
Thank you.